between the Rittenhouses and the Fight Back Foundation. And there's one other claim that's lingering here, and that is?
It's the claim on the Patent and Trademark Hedge Fund on behalf of Carish Capital, who was a loaner of some of the money, as well as holds a security interest in all the assets of John Pierce.
Mr. Richards.
As this attorney it's signed by Mr. King, filed the court paperwork moving Mr. Resnick in pro hoc vice.
She's appearing here. Mr. Resnick's not submitted any paper to me to appear.
And Mr. Resnick is the individual who filed the paperwork, and if he's not admitted pro hoc vice, I would ask that the paperwork be stricken and that the stipulation between the parties go forward, not even addressing the questionable merits, to say the least, of the claim. The documents that have been filed with the complaint predate the events in Rittenhouse. They're signed on February 25th and 26th of 2020. The shooting, which is the subject of all these events, happened, as the court's well aware, August 25th of 2020. They talk about being out approximately $3.5 million with costs from an arrangement between the funding and Mr. Pierce to fund Carter Page and some other individuals' lawsuits. Nothing to do with this. They're out $3.5 million, and then according to paragraphs 16 and 17, they then loan another $300,000. There are no documents whatsoever reflecting that. In our pleadings and in Fight Back's pleadings, it shows that all of the monies came from Fight Back to Mr. Pierce's trust account. He has said he has no interest in any of the monies. It was not his money. And maybe things are different in California or New York, but I don't believe any lawsuit can validly move against an attorney's IOLTA trust account. It's not their money. It wasn't Mr. Pierce's money. And as I said, as to paragraphs 16 and 17, in their documents talking about a loan of $300,000, there is absolutely no documentation. So we're supposed to believe that they're out $3.7 million, and then they'll just give another $300,000 with no paperwork, surety, or anything else signed by anyone involved in this case. Nowhere is Fight Back named. Nowhere are the Rittenhouses named in this matter. And it's not timely filed. This has been going on now since November, when we filed our paperwork. Fight Back filed their paperwork, and I believe yesterday or the day before, finally, Mr. Resnick and Mr. King filed this document asking to get involved a day late and a couple of $100,000 short.
Did you have a comment?
Just on top of what Attorney Richards indicated, that the money that was posted by Mr. Pierce, that money came from the foundation, which was transferred to Mr. Pierce's trust account. Other than that, I concur with Attorney Richards, and I do ask the court to approve the stipulation.
Did you want to respond?
Yes, Your Honor. I don't have the receipt that the remittance receipt that Attorney Pierce has in his possession, or has provided to the federal court in Texas for the interpleader case. There is mention in the documents of an interpleader case federal court, which was filed November 9th, 2020, and includes the Fight Back Foundation as a defendant, asking that the court in Texas, Northern District of Texas, make decisions about this money.
Your Honor, that matter was filed, a copy of that, I believe it was by my office, with this court. Also, Mr. Solis had it, and that had the proof that the money was wired from Fight Back to Mr. Pierce's trust, $2 million, not $1.7 million, from Fight Back to Pierce's trust. Nowhere is there any mention of $300,000 coming from the hedge fund or the successor, Carish Capital. So they're coming in, they have absolutely no documents, no proof of standing, nothing, except an unadopted, unauthenticated acceptance of judgment that was signed in New York on February 18th of 2020, once again, before the Rittenhouse matter even occurred in August 25th of 2020. So where's the proof of this $300,000 that supposedly came into this $2 million?
Well, I can tell you that the clerk here, Mrs. Lima, who runs this operation, has spent a lot of time on the phone and internet, with California. And they've been asking her a lot of questions that are, some of which she's had to decline to answer because she's not permitted to. But she has told them that she can't accept filing. First they tried to file things by email, which they can't do. And then there were some things came in over in the proper filing system, but they're not filed by attorney. The claimant here is, it says it's, well, I'm not entirely clear. It says it's an LLC. In the state of Wisconsin, a corporation must appear by an attorney. So there was no attorney filing these statements. Then in addition, I looked at the affidavit that was filed by Mary Ellen Johnson. Which is, well, I don't know what's going on here. Some of it appears to be out of sequence. Look at page 12, line 23. I don't know about that. But there's misspellings and the like, so it looks kind of haphazard. But the critical thing that struck me was page 5. Starting with line 15. After the events that arose in Kenosha, Wisconsin in November 2020, which is also inaccurate, gave rise to the arrest of Kyle Johnson, and determined in her capacity as CRO of Pierce and PB that investing in Kyle's bail fund would be a good investment for the trust because she and the trust believed Kyle would in fact eventually be that's quite a leap of faith, in any criminal prosecution, whether it's the Rittenhouse case where there certainly were suggestions before the trial that it was going to end up in an acquittal, that would be quite a leap of faith that to put $2 million on. And then it says, a good investment. Accordingly, the trust contributed $300,000 of its own funds towards Kyle's $2 million bail fund, expecting to receive back its original investment plus interest at the legal rate. Who was going to pay the interest? We weren't. This is bizarre. So I don't know.
Your Honor, I believe that to respond to the question of these matters having occurred prior to the Kyle Rittenhouse case, the UCC filing statements, the lien, the merchant agreement, these were all sources of the lien that the fund and therefore and Carish Capital thereafter had on Mr. Pierce's or Attorney Pierce's law firm assets. And I don't think it matters whether or not it occurred before.
Well, is a trust account an asset of the law firm? But this issue was litigated, a similar issue was litigated in the case of the Archdiocese of Milwaukee when the claimants tried to get at the funeral fund, the
Right.
cemetery fund.
Sure.
That's separate money.
Yeah.
That wasn't Mr. Separate money. That wasn't the attorneys to pledge. And he in fact pledged it, according to what I've got before me, as money in trust for the benefit of the defendant. And take a look at 757.34. It's illegal for a lawyer to post bond on behalf of a client.
My issue here is that I am not privy to the documents, in particular the remittance receipt, and the statute is clear that the bond or the bail bond would be returned to the person or persons that posted it.
The person to whom is entitled to it.
Correct. The person who paid the money. And I don't have that receipt to be able to say one way or another that Mr. Pierce posted it personally or on a trust fund.
That was filed, it's in the court.
Yeah.
And if Carish or the other entity wished to get involved in this, they could have joined in the interpleader action, which Mr. Pierce filed in Texas, saying he didn't have any interest in this. The money's posted from Pierce's trust account to Kenosha County. When it's returned, Mr. Pierce has said, it's not mine, I have no interest. It should go to Fight Back, Kyle Rittenhouse. If the money comes back, it does not somehow then turn into non-trust fund money. So they have no interest in it. They don't have the pleadings to support any interest in it. The fact that she doesn't have the paperwork, where's Mr. Resnick? Why isn't he on the phone emailing some debt owed or some promise made, which doesn't exist?
If I may, Your Honor, I'm not privy to the stipulation that was made between or amongst this. Who was the stipulation made between Mr. Richards?
You're not a party.
I just want.
Between Fight Back, as has been stated, Kyle Rittenhouse.
But not the state.
The state has no interest in the bond.
Well, I'm not here to. No, I don't.
I've got I found the bond receipt, I'm just looking for. In the system. I've seen it at some point. Was that in your materials, the receipt? No. The 2 million, yeah. But is there an actual photo of it? Or an image? I swear to Pete I saw one.
I think what was filed was the wire transfer documents.
Your Honor, the remittance receipt is available and was filed in the Northern District of Texas.
And we filed a copy of the interclear action with our documents, which is the Northern District of Texas.
I have a copy of the interclear action. It doesn't have the document.
The check I've seen, but I thought I had seen I also have that. But there's another document, the actual receipt. Find it.
Your Honor, my counsel from Florida is watching on television, and he's going to text me the document. My associate says that the wire transfer receipt is e-file document 441.
I think
441.
I don't think that's the one I'm talking about there. I don't know, I can't, locate it now, but, I've been looking through this over the last few days. And, I believe there was an actual receipt issue. With the signature of, maybe I'm wrong about that. Signature of,
Your Honor, I believe the interpleader complaint has the remittance receipt attached, and it is document 442.
no, that's not what I'm looking for.
I also have a copy.
Copy of,
John Pierce being given a receipt for $2 million at 1:53 p.m. on November 20th. That was the mandatory court date. See it on my cell phone.
yeah, if you wanna show it now. Don't display it.
I don't think it's today in our
That's, I think, what I'm looking for. That's exhibit A on your, on which document?
$441, I think. 441 or 442. The interpleader is 442. The wire transfer receipt is 441. That's the receipt that was exhibit A, I believe, in 442.
What was the date you filed it?
That I don't have open. Would have been shortly after the acquittal. That's probably that day or the following day.
When the motions were filed, I think they were the next day. Double check.
My associate says they were filed on November 19th.
again to the other council if they want to see it, and then bring it up here. And do you know anything about increasing the size of the image
Are you talking about me?
on the phone?
My associate said she could email it to the court, and then you'd have a good copy of it.
That would be great.
Okay.
Email it to Mrs. Lehman.
Okay. My associate stated she's has emailed. I'm just getting her on speakerphone.
Yeah, that's not what I'm looking for.
Do you have the receipt?
Is there another receipt on there?
The one that Shane,
What I'm looking for, there is a document which I recollect with the signature of Mr. Pierce, which also,
lawyer transfer one, you're looking for the one that the court gave to Mr. Pierce when he posted it.
it's the document that actually has the word for the benefit of.
I know what document he's talking about. Yeah, at the bottom it says for the benefit of Kyle Rittenhouse's boss.
Yeah, that's the paper I'm talking about.
Let me grab it.
Well, I'm glad that you verified that there is such a document. I thought maybe it's in my head, but I definitely saw it.
It might have been the
Lawyer transfer, like that.
to John Pierce. And then at the bottom of the side for,
And that's document 441. She's looking at it right now.
Does it say for the benefit of,
It says for the benefit of Kyle Rittenhouse.
right?
For benefit of Wendy Rittenhouse as legal guardian for Kyle Rittenhouse.
Yeah, that's it. That's the document.
yep, that one.
Yep.
Yeah, it says for the benefit of. That's a trust. Every indication here is for trust. If you want to pursue this matter, then I'll have to have this. Oh, is that where it is? I thought it was handwritten too. But anyway, you know, if I thought this were a close issue, because I don't, I would have to invite Mariel Johnson here to be examined about the statement about earning interest of a criminal bond.
I'm sorry, Your Honor.
Earning, she stating that she felt that the investment in the investing in a criminal bond would be a good investment for a hedge fund. I understand they take some risks, but that would be something I would want to hear testimony on. Not only that she felt that it was a good risk, and she was confident of the outcome of a criminal case when there were 7 counts, and of course that the defendant won't flee, which is always an issue in every criminal case, or get arrested for some minor crime, which under Wisconsin law justifies forfeiture of the bond, or and thinking that it's going to draw interest from the court. I would want to examine about that.
Your
But I
Honor,
don't think it's a closed case, so I'm not going to go down that road.
I actually think that the issue here is the return of the deposit should be returned to the person who made the deposit, their heirs or assigns.
Well, first off, the lawyer can't lawfully post a bond.
To the extent that he did post the bond
Well,
and was
Who did?
attorney of record.
huh? Your whole theory is that he posted the bond, no?
Correct. He did post the bond. Personally.
Yeah, that's not what it says.
The receipt was made out to him at his home address, and if it was not appropriate for him to post the bond, then he was the attorney and attorney of record, so he did it.
If you want a hearing, we'll have a hearing, but this person who made this declaration and submitted it to the court is going to have to appear here for examination.
That's fine, Your Honor.
Your Honor, they haven't made even a preliminary showing. None of the documents that she filed, well, she didn't file because it was filed by Mr. Resnick through Attorney King, who's not here. None of those have been adopted or verified or authenticated and made legal here in the state of Wisconsin.
Well, we don't have to have verified pleadings in this state.
Your Honor, they haven't even shown the receipt or some agreement between Mr. Pierce, which he couldn't legally sign. He couldn't give away interest or IOLTA monies and an interest in them. The money came from Fight Back through John Pierce's trust account to the Kenosha County bond. Mr. Pierce has now washed his hand of it. I don't have an interest. He's telling the truth. I have no interest, no ability to have an interest in a bond. Give it to the 2 people who are there, Fight Back, Rittenhouse, and Mr. Schroeder.
With all due respect, he has said, I don't have an interest in the bond. I'm going to file a complaint, an interpleader complaint in the federal court of Texas because there's a bunch of people who think they have it, include not just Fight Back, but Milo Fund, which I'm not familiar with. So Mr. Pierce hasn't said that it should be given to these 2. He said it should be decided by the federal court.
They haven't joined the interpleader, which they're admitting they're aware of.
Not yet. We haven't
Well,
received.
you're not yet. You don't have to be standing here today.
The time for answer has not
There is
come
no answer. It's a criminal case.
to the interpleader action.
There isn't an action. There has been no action filed in this country.
No, to the interpleader.
There's no. I'm talking about the action that's here under the jurisdiction of this court today. there's this document filed, motion of assignee of judgment creditor, Parish Capital LLC for turnover pursuant to section 1.11 in an agreement. Is this an application to the court for an order is by motion? Is this a motion that's recognized in Wisconsin? I just don't think the request is being made for this hedge fund to intervene in an action in which it has no legal standing in Wisconsin. Filed by an attorney who does not indicate that he's licensed in the state of Wisconsin. And it doesn't have your signature on it, so it doesn't have any sponsorship by any licensed attorney in this state. So I'm going to order that the bond be distributed in accordance with the stipulation which has been agreed to by the other parties. Anything else?
No.
No, thank you.
Correct, you can email.
Yeah.